So as Lisa stated, I'm a partner with Fallsgraf Beinhauer. We're better known as PB Elder Law, and the firm is dedicated just to the practice of elder law and estate planning, ranging from your basic estate planning documents like wills, powers of attorney, and healthcare proxies to more advanced planning like the incorporation of a revocable trust or an irrevocable trust. And then we also deal with a lot of Medicaid related issues from nursing home coverage, etc. So I'm going to start today just by explaining the three basic documents. I think everyone needs to know how those truly operate. There's a lot of myths out there about how they operate, so let's just get that on the table about how those things operate. We'll then talk about a living trust, which is a revocable trust designed to avoid probate. And then we're going to talk about Medicaid and how we can use an irrevocable trust to start getting assets out of your name to reduce yourself as a Medicaid spend down target should long-term care costs ever be an issue in the future. So as was indicated, if you have questions, just throw them in the chat. I'll try to get to as many at the end as I can. You can always feel free to shoot me an email or give me a call after, and I will try to get back to you on any questions you may have. So the first of the basic three documents, everyone should have these three documents as soon as you turn 18. It's a will, a power of attorney, and a healthcare proxy. A last will and testament is a legal document that provides instructions regarding how you want your assets distributed upon your death. Not everything is distributed through your will, and as you're going to see in this conversation today, really the goal with proper planning is to never use your will. Anything that is jointly owned will pass to the joint owner upon your death. So if you and your spouse own your house together, or you own your bank account together, or you have an investment account together, and the first spouse dies, the second spouse has to do nothing. They just become an owner of the account by virtue of being a joint owner. So if my will says I leave my joint bank account to my child, but my spouse is joint on the bank account, the joint ownership will control, not the designation that's in the will. Additionally, anything that has a beneficiary, like a retirement account, life insurance, you can put beneficiaries on your bank accounts if you want. Anything that has a beneficiary designation upon death will pass to the beneficiary. It will not go through the will. So with proper planning with an elder law attorney, the objective really is the will is more of a catch-all for anything that may pass through your name individually with no joint owner or no beneficiary. But with proper planning, everything will pass to your intended beneficiaries in a timely and much more cost-effective manner. Someone that dies and has assets that pass through their individual name goes to a legal proceeding, what's called probate. All probate means is we're submitting the will to the court for court approval, and we're requesting to have an executor appointed. Just because you're named as an executor in the will does not mean you are the executor. I get those calls, so do other elder law attorneys all the time. So-and-so died, I'm the executor. No, you're the nominated executor. If we have to use the will, you have to apply to the court to be the executor, and if no one objects, the court will then appoint you as the executor. From the date that the executor is appointed, an estate minimally needs to remain open for 7 months. That's a creditor claim period, so any debts you may have had at the time of your death can be filed against the estate to be recovered. In Erie County right now, there's about a 4 to 5 month backlog from date of filing for an executor appointment to the date you're actually appointed. What that means is the assets are effectively frozen for about 5 months. So by the time you get your executor appointed and then you start the 7-month window, an average probate proceeding is running about 15 to 18 months right now in Erie County. As we're going to talk about today, there's much more time and cost-effective ways to get your assets passed to your beneficiaries, short of having to go through the court system. So although everyone should have a will, you should be thinking of the will as really a catch-all, not the initiating device of how assets are going to actually be distributed. What happens if you die without a will? I often hear, well, hey, my spouse is going to get it all. If I don't need a will, why would I do that? Well, maybe. If you have a spouse and you have kids and you die without a will, you die what's called intestate. And now New York State dictates how your assets will be distributed. If you die with a spouse and children and assets pass through your will, the spouse gets the first $50,000 and then the next one half. Your children get the other one half. So if your intended distribution plan is everything to the spouse first and then the kids, you need a will to say that, because that's not going to occur if you die without a will and then assets pass through your estate. Your children will end up with about 1/2 of the assets under that example. A will is also a critical planning tool for those of you that may have young children, or if your children have children, you can use a will to name guardians if something were to happen to the parents. New York State, the age majority is 18, so younger parents often use the will as a tool to describe who will raise their children or who they want to raise their children in the event they pass away and their children are under the age of 18. For those who may have disabled beneficiaries, talking with an attorney who doesn't do estate planning, they're probably going to tell you, well, you can't leave anything to that individual. They're disabled. If you leave a beneficiary or distribution to them, you'll kick them off of their benefits. That's not true. There are ways to leave assets to disabled beneficiaries without replacing their benefits, specifically SSI and Medicaid. So for a disabled individual who's receiving SSI, the maximum resource allowance is $2,000 a month, but the bigger component is Medicaid. That's their health insurance that they get as a supplement to the SSI. If you outright leave a distribution or a beneficiary, I leave an asset, or my will says all to my disabled child, and it says nothing beyond that, and my disabled child in fact inherits, you will kick them off of their benefits. So how do you leave things to them? In your will, you can create what's called a supplemental needs trust. It's a third-party supplemental needs trust. And all that means is I am setting up the trust on someone else's behalf. So it's my money that I'm leaving to them as opposed to their money that they are putting into a trust for themselves. The supplemental needs trust can be used. You appoint a trustee. The trustee can use the money to enhance the disabled individual's life, pay for things that their benefits don't pay, cars, vacations, other things that they may need that SSI and Medicaid don't cover. It cannot be used for cash, food, or shelter, but pretty much anything beyond that scope, the money in the trust can be used to enhance the child's life or the disabled individual's lifetime. And the nice part is whatever's left in that trust upon the death of the disabled individual, it pays to a beneficiary. It does not get recovered by SSI and Medicaid. So that's the primary difference. If an individual inherits and is disabled, they can create a supplemental needs trust for themselves. But by doing that, whatever money is left in there, Medicaid and SSI will recover against that trust. As opposed to you as the parent setting up a supplemental needs trust for your child. When you die, the money will go into that trust, but because you set it up for your child, there's no lien recovery, whereas there is lien recovery if the child inherits outright and then sets it up for themselves. So there are ways to leave assets to your disabled beneficiary, something you definitely need to talk to your elder law attorney about so that you don't have unintended results where you kick them off of their benefits or otherwise subject money to lien recovery after the death of the beneficiary. One more thing I want to touch on, on page 1. If you have beneficiaries that you want to set up a trust for because they're too young. So as I mentioned, the age of majority in New York State is 18, which means if your will says nothing other than I leave my assets to my children or my grandchildren and they inherit, they will get whatever you leave them at the age of 18. There are ways to set up trusts within your will so that the beneficiary's money is set aside until they're 21, 25, 30, whatever conditions you want to establish. The money is managed by a trustee. It can be accessed for pretty much any purposes by the trustee. So health, education, welfare, etc. And then when the individual reaches that specific age or ages that you have established, then the money is paid out. So a lot of times, commonly what an elder law attorney will see is age 21, age 25, with the idea being, well, the money would be set aside and get them through their educational phase of their lifetime. And if they choose to blow it thereafter, well, hey, that's on them. I got them educated and they should be at an age where they're financially responsible, as opposed to 18 where you're guarding against the beneficiary going to Vegas and putting it all on black and blowing through the inheritance or some crazy thing like that. So there are things that you should be discussing with your elder law attorney when you're talking about potential younger beneficiaries inheriting and how to set something up to guard against the money being dissipated before, it's used for whatever purposes you'd like it used for. The second of your basic 3 documents is your healthcare proxy or your living will. If you've been to a doctor, you've signed one of these. A healthcare proxy is a medical directive. that effectively indicates what type of treatment you would like if you're unable to make your own decisions, and who will be the agent and backup agents to make those decisions. With respect to executors and powers of attorney under, or an agent under a power of attorney, you can name multiple agents to act at the same time. On a healthcare proxy, it has to be one agent and then the next. So you can't have co-agents, but you can appoint one and then you can create your succession line if you'd like. The ones that you've signed in the hospital, they probably say nothing more than I, Dan, appoint so-and-so to be my agent. He or she knows what I want. Those work, but the problem is if you have no spouse as your agent and you have 3 children, you would name child number 1, child number 2 is successor, child number 3 is successor. You're unable to make your own medical decisions and you're now incapacitated. And it's getting to the point where we need to make a decision about does the agent or does the individual want to be prolonged artificially by breathing tubes and feeding tubes, or do they want a do not resuscitate order? Well, child 1, who's the agent, is out in the hall saying, well, mom or dad said they don't want to be resuscitated, they don't want to go through this, they want a do not resuscitate order. Child 2 and child 3 are in the hall saying, no, that's not what mom or dad told me. They said that, they wanted to be prolonged as long as possible. Although child 1's child A, their decision should control because they're the agent. If everyone's out fighting in the hall, you can expect that the doctor is going to be reluctant to do anything major as far as pulling the plug because they can just smell the lawsuit coming. If you have a more documented document, like a healthcare proxy with a living will, and the document specifically sets forth what you would like, in lieu of just saying somebody knows what I want, but instead says maybe, I want all available medical treatment, but if I get to the point where they're only going to keep me alive artificially, or I have a terminal condition, or whatever the case may be, I'd like a do not resuscitate order. Now the kids are all looking at the same document and can see what mom or dad signed and the specific directives they gave. And now an otherwise very difficult time can be made easier because the agent isn't making decisions for mom or dad. They're instead facilitating the decisions that are already in writing. So I definitely recommend everyone has a healthcare proxy. The healthcare proxy will have HIPAA language in it. HIPAA is the law that protects against doctors and nurses being able to disseminate medical information without the individual's approval. So having the authorization in there is critical because now the individual's agents can talk to the doctor and make informed decisions about what kind of treatment should be performed. And then finally, there's a separate standard New York State form. You don't need a lawyer to prepare this. It's called the MOST form. It's a medical order for life-sustaining treatment. That's the actual DNR to be put in place. So the healthcare proxy and the living will gives the authorization to put the DNR in place. The MOST is the actual, okay, now the DNR is in place. So that's a separate form you can sign through your doctor at any hospital you're at, but you do not need a lawyer to prepare that for you. Finally, on a healthcare proxy and a living will, again, if you're going to sign one outside of the hospital under the advice and guidance of a lawyer, just make sure you file it with your doctor thereafter, because when medical emergencies happen, no one thinks to run and get the healthcare proxy. Everyone runs to where the emergency is. So if it's part of your electronic medical record, the likelihood is it'll get from your doctor's office to the hospital so that you can then begin making decisions as the agent for the person who's incapacitated. The third of your basic 3 documents, and probably the most critical in-life document, is a power of attorney. So a power of attorney is a legal document that appoints an agent or agents to assist you with anything you yourself can do with your finances. Bill paying, income taxes, applying for governmental benefits, beneficiary changes, asset protection from Medicaid, which we're going to talk about in a bit. It effectively appoints an agent to stand in your shoes and do everything you yourself can do. So, the thing that an elder law attorney always hears, well, why do I need to do this? My spouse can do it all for me. No, they can't. They can act on a joint bank account. So if you and your spouse are joined on a bank account, you each have equal access. But let's say we need to access the wife's 401k. She has no power of attorney and she's become incapacitated. And we now need to access that 401k because we have a large expense or something we need to pay. The husband calls Vanguard and Vanguard says, okay, where's the power of attorney? Well, I don't have one. Well, sorry, you have no access. But I'm the beneficiary. Why can't I access it? Well, because beneficiary designations have no control until the person dies. So even though you're the beneficiary and you're the spouse, they're not going to talk to you. The same thing applies if we need to sell a house. The individual's incapacitated, they're going to a nursing home, we need to sell the house or we need to change the deed to the house. You can't sign your spouse's name without a power of attorney. So the misconception or the myth that, hey, we're married, we can do everything for each other, that's wrong. You need a power of attorney. If your power of attorney was done pre-2010 and is only a 2-page power of attorney, you need a new one. The law was updated substantially in 2010 and again in 2021 to build in all sorts of Medicaid planning authority for people going into the nursing home that haven't done any advanced planning. Again, we're going to circle back to this, but the point is, if your power of attorney is only 2 pages, or if you have a power of attorney post 2010 and it does not have what's called a statutory gift rider or gifting authority, it needs to be redone. If you require long-term care down the road and you have too much money, if you have a gift rider or gifting authority, your elder law attorney can work with your family to save about 50% of your assets instead of paying 100% of all the assets above and beyond what you're allowed to keep over to the nursing home. So this is why this is a critical planning tool, is the power of attorney allows the family to work with an elder law attorney, even if your spouse or your family member has 1 foot in the nursing home, has 2 feet in the nursing home. There are still things that can be done to preserve assets short of paying 100% of your excess resources to a nursing home. We'll talk more about this when we get into the Medicaid section, but that's really why this is a critical planning document. Elder law attorneys always get called and say, hey, so-and-so has died, I'm the power of attorney. Well, with death, your power of attorney authority terminates. So the power of attorney is an in-life document. After death, you're either going to be an executor or you're going to be a trustee if you have any authority to manage the affairs of the deceased individual. But a power of attorney terminates with death. So what happens if you don't have a power of attorney and the individual becomes incapacitated? The only way to get authority to act on your spouse's behalf or parent or whomever is to go to court and do a guardianship. A guardianship is a petition to a court to have someone declared legally incapacitated. A court attorney an attorney is appointed for the alleged incapacitated person. The court appoints a court evaluator who is the arm of the court to go out and investigate the allegations. And then you yourself need an attorney. The proceeding is protracted. Generally, you're going to spend thousands of dollars doing it. And every year you have an annual reporting requirement to the court to show everything you've been doing with that person's finances. None of that is required under a power of attorney. So power of attorney is a much more cost-effective way to get authority for your spouse, your parent, whomever, and store it away. Even if you're totally healthy right now, sign it, store it away. It's there if you need it, and it avoids a very long, protracted, costly guardianship proceeding that's really unnecessary just by virtue of having a power of attorney. June 2021, there was a change again to the power of attorney law. Really what they did is from 2010 to 2021, the power of attorney went from 2 pages to about 13 or 14 pages. And again, it all has to do with this ability to protect assets from the nursing home if you haven't done any advanced planning. That's the primary function of what was built in. Under the old power of attorney from 2010 to 2021, if you wanted to be able to do the Medicaid planning, you had to sign a specific separate gift rider. If that wasn't executed, you couldn't do the gifting. In 2021, they just built the gift rider right into the power of attorney. So now it's all included in the document. So really it was more of a format change. The other thing that it did though, and this was critical, was it put financial penalties and consequences on financial institutions who were rejecting powers of attorney for no reason. Hey, there was a typo. Hey, there was this. We would deal with this. Elder law attorneys would deal with it all the time. Where we're trying to do a Medicaid application, we're trying to request the 5 years worth of statements. We send out the information to the facility or to the institution, and the institution rejects the power of attorney. Pre-2021, there was no recourse. Now there is. Now the institution can be sued and can be ordered to pay attorney's fees, sanctions, and everything else. Ultimately, what we have seen as elder law attorneys is the rejection rate from institutions has gone way down because now there are consequences to them for rejecting things for really just silly reasons that had nothing to do with the basis of what the document was for. So that was the major other component to it. Now we're going to move into the estate planning. This is going to be just a quick part of the program. We get these questions all the time, so I wanted to just highlight it for you. And then we're going to move into the trusts and the Medicaid and the asset protection. So questions we always get. When I die, am I going to pay an estate tax? The question is, if you're rich, yes. By rich, I mean in New York State, if you as an individual die with more than $6.58 million in your particular or in your respective name, you'll pay an estate tax. Otherwise, you won't. At the federal level, it's almost $13 million per individual. So more people than not will not pay any estate tax. If you are above these estate tax limits, or there's a possibility that you could end up being above them, you need to see an elder law attorney immediately, because there are planning techniques that can be implemented to avoid paying large estate taxes upon the death. The way New York State works, if you die owning just 5% more than the estate tax, they tax you on the entire value of your estate. It's upwards of $1 million in estate tax, potentially more depending on what the value of your estate is. That can be eliminated and avoided by meeting with an elder law attorney and implementing techniques to either do gifting, donor funds, charitable distributions, or if you have a spouse, setting up what are called disclaimer or credit shelter trusts, so that if the spouse inherits, any money above the 6.5 goes into a separate trust instead of being taxed at the estate tax threshold. So again, kind of the bottom line is, if you're under these numbers, no estate tax. If you're around these numbers or over, you need to meet with an elder law attorney immediately to walk through what types of planning techniques are available to minimize or otherwise try to get away with not paying estate tax. Now we're going to talk about trusts. So the first trust is called a revocable or a living trust. The sole purpose of this trust is to avoid probate. Again, what is probate? Probate is the legal proceeding where someone dies with assets in their individual name, no beneficiary, no joint owner, and now we need to use the will, and now we need to go through the court system, which is now currently taking about 15 to 18 months and will cost a substantial amount of money in attorney's fees, costs, disbursements, etc. Assets that are owned by a living trust pass immediately upon the death of the owner of the trust or the creator of the trust. Nice part about a living trust. I create a living trust. It's called the Dan Schuller Living Trust. I can be the creator of the trust. I can be the trustee of the trust. And I have all the access to any of the assets that are in the trust. So all that is really being done is either we are retitling my bank accounts from my name personally to the name of my trust, or I am naming the beneficiaries of my assets to be this trust so that upon death, everything pays into the trust and then distributes according to its terms. The distribution provisions are much like a will. You know, if my plan was upon my death, everything passes to my 3 kids, well, the living trust would say the same thing, except that it doesn't have to go through the court system. Again, it passes in a very timely fashion to whomever the beneficiaries are. Upon my death, I have a named or a successor trustee who steps in, manages the trust now that I've passed away, and distributes the assets according to whatever the terms of the trust are. This is also a great planning tactic or planning tool for people who own property in multiple states. So our snowbirds who are in Florida, the Carolinas, Arizona, wherever you may be. If you own property in New York and you own property in Arizona, Florida, North Carolina, wherever, you die with assets in your individual name, you will need to do an estate proceeding in New York. And if you also have a condo or whatever in one of the other states, you die in your individual name, you need to do an estate proceeding out there as well. So now you've duplicated your costs and your time associated with passing these assets. If the trust is the property owner, so the trust is the owner of my house, so on my deed it says the Dan Schuller, Living Trust, and the same thing on my deed out in Arizona. When I die, those assets pass through the trust. So there's no estate proceeding in Arizona, there's no estate proceeding in New York. Now the assets pass again in a very timely fashion, in a cost-effective fashion, to whomever my beneficiaries may be. What is the downfall of this trust? The downfall is if you're looking for asset protection from the nursing home, this trust provides zero. It is a living trust. So the pros are, it avoids probate, and anything that is in there, you still have full and complete access to the money during your lifetime. The con, there is no Medicaid protection because you still have access to everything that is in there. So who is someone that may consider a living trust? Someone who's self-insured. Meaning if I ever had to go to a nursing home, I have enough money to pay the $15,000 or $20,000 a month they're billing me to be there. The second would be somebody that has long-term care insurance. That would be a supplemental insurance policy that you probably would already have purchased, and what it provides is a daily benefit so that in the event you require long-term care costs, it's a policy that pays a monthly benefit to help assist with payment of the nursing home. Those are less and less frequent. I know personally as an elder law attorney, maybe 3 to 5% of the clients that walk through my door have one of those. Most people do not. That's okay. As the discussion that we're about to get into, we're going to show you that there are ways to get access to a means to paying the nursing home other than long-term care insurance and other than being self-insured. So again, for the revocable trust, major takeaways are it avoids probate, it helps distribute assets in a timely fashion, and you still personally have access to all the assets and the money that is in the trust during your lifetime. The other takeaway, it provides no asset protection from the nursing home. Okay, let's talk about Medicaid, which is going to tie into the second of the most common trusts that elder law attorneys are dealing with. So let's talk first about Medicare, because oftentimes an elder law attorney, people come in, they're talking about Medicare when they need Medicaid, etc. So let's just talk about how the process generally works. Once you're 65, you have Social Security. You get Medicare as well. Medicare is a premium that's deducted out of your Social Security before the money hits your bank account. So you may not even know that you're paying for Medicare, but it is being deducted from your Social Security. So the amount hitting your bank account is a net amount after your Medicare premium has been paid. Every year you get a benefit statement, probably in the fall, the winter of the upcoming year, which will tell you what your benefits are for the next year. And it also shows you a breakdown of how much you're paying for that premium. So if you have to go to the hospital, your underlying health insurance covers Blue Cross, Univera, Independent Health, whomever you have. Once you are discharged from the hospital, if you are sent for rehab, Medicare picks up for a maximum of 100 days. Medicare also has prescription drug plans, Part D, to assist with payment of any drug plans you may have. But what happens if A, you exhaust your 100 days at rehab, or before you get to 100 days, the assisted or the rehab facility says, hey, this individual is not going to improve anymore, and now they cut you off. And they say, okay, you need to go to skilled nursing, 24-hour care. That's where you're looking to Medicaid. So what is Medicaid? It's a welfare program. Does it mean that you're in fact poor? No. It means that your elder law attorney made you look poor, either through advanced planning, getting assets out of your name more than 5 years in advance of applying for long-term care, or implementing what's called a crisis plan through a promissory note and a gift, which we're going to talk about in a few minutes. So in 2006, the law was changed substantially with respect to Medicaid. The look back was extended from 3 years to 5 years. The look back is 5 years from the date of the application. They also changed the way that they dealt with gifting issues, which we're going to again talk about in a second. Finally, they dealt with annuities. So annuities are an elder law attorney's worst nightmare when it comes to Medicaid. If you're applying for Medicaid and you have an annuity, a non-qualified annuity, or you have an IRA annuity, even though it's an IRA, it's an IRA annuity. A condition of qualifying for Medicaid is that you name the Department of Social Services as a beneficiary, which means that when you pass away, whatever's left in that annuity will first be recovered by the Department of Social Services before it pays out to the beneficiary. So kind of the bottom line is, once you're hitting that 65 and up age, if financial advisors are talking to you about annuities, you need to keep in mind that this could be an issue down the road. You could end up having to name the Department of Social Services as a beneficiary should you require long-term care. There are things we as elder law attorneys can do to try and avoid that. It could be an issue is kind of the point. So be careful with the annuities is the disclaimer that we always give. If I need a nursing home, how much money can I keep? The person going into the nursing home, otherwise known as the applicant or the institutionalized individual, can keep $30,182 in resources. What are resources? Resources are anything that is not a retirement account and is not income. So bank accounts, cash value on a life insurance policy, non-qualified annuities, stocks, bonds, brokerage accounts, anything that is, again, not a 401k, not a 403b, not an IRA, not a 457 New York State plan, etc. For income, they can keep $50 a month. That's it. They can also prepay their burial plan in an unlimited amount, cremation or burial, and they can keep life insurance with a face value of $1,500 or less. So as the institutionalized individual, it's $30,000 in cash, pretty much. The community spouse, meaning my spouse living in the community, not in a facility, but in the community, can keep a maximum of $148,620 in cash, the examples we just went through. They can keep a house so long as the equity is under $1,033,000, which is most houses. They can keep a vehicle of unlimited value. They can prepay their burial plan, and they can keep $3,715 per month in income. In certain circumstances, there's the ability to keep more than $3,715, but that's getting too much in the weeds for today's conversation. What else can you keep? You can keep your retirement accounts. So this is a big one. This is why people always come in and they say, well, I'm not going to qualify for Medicaid. I have too much money. I'm not poor. Well, that's just not true. There are millionaires in the nursing home on Medicaid. And how do you do that? Well, any traditional IRA, 401k, 403b, 457, or any other Roth IRA, any other type of traditional retirement account, the principal balance is exempt, meaning it doesn't count towards the $30,000 or the $148,000 you're allowed to keep. It's a specific exemption under the law that allows you to maintain your retirement accounts. What do you have to give up? You have to give up the income that it produces. So if the applicant, if we have an individual going into the facility and they have $1 million retirement account, and that retirement account pays out $80,000 a year in income, Medicaid divides the $80,000 by 12, and then each month, 1/12 of the $80,000 is contributed to the nursing home on the applicant's behalf. But the $1 million retirement account, the principal balance that remains invested in the market, that does not have to be liquidated. And when the individual dies, whoever the beneficiaries of that account are will inherit free and clear of Medicaid. So that's a big one, because most people are always taught, hey, sock the money away, put it in your retirement account. So a lot of times people will come in to see an elder law attorney thinking, oh man, I'm in big trouble. I got $1 million in my retirement account. And then we get to tell them, no, you're not. That $1 million, the principal is exempt. Only the income needs to be contributed. There are also specific rules to exempt transfers if they're a disabled child. You can exempt additional assets to disabled children above and beyond what these eligibility rules are. Or if your child lives in the house with you for 2 years immediately preceding you applying for Medicaid, you can exempt the house to you can exempt the house to that particular caretaker child. Community Medicaid is another program. So generally when you're talking about Medicaid, you're hearing or you're thinking the nursing home. There are other types of Medicaid programs available if you're in assisted living or if you're in your home to help offset some of the costs associated with assisted living. Assisted living is usually about $5 to $7 grand a month, depending on the facility. If you're at home getting care, well, whatever the aides are charging times however many hours per week you're requiring care, that's all out of pocket. There is a community Medicaid / nursing home diversion program, and conceptually, the idea is the resource amounts are very similar to what's with skilled nursing. The individual that's applying can keep a little bit more in income because they have more expenses. They're not 24/7 skilled care. They have other expenses like room rates, etc., that they're going to need to pay. So the individual can keep about $1,600 a month, but the rest of the income has to be contributed to a pooled trust if it's over and above and beyond that. Community Medicaid is set up so that it assists with payment of those nursing home bills, or assisted living bills, I'm sorry. Here's the big takeaway though. Nursing home Medicaid, there's a 5-year look back. Community Medicaid, in October of 2020, a bill was introduced to create a 2.5-year look back. However, COVID hit. And now I think the legislation has been looking at it over time and figuring out it's a very difficult look back to implement. So right now there still remains no look back. So what does that mean? Client comes in to see an elder law attorney, single individual. They have $230,000 in assets. We tell them you're single, you can keep 30 grand. The other $200,000 we can transfer out, put into an asset protection trust, which we're going to talk about in a second. And then on the first day following that transfer, we can apply for Medicaid for them. There is no consequence to doing that because there is no look back for community Medicaid. So they can't penalize you for transferring assets before you go into the nursing home, unlike skilled nursing Medicaid where they can. So let's talk about how that really works, because you'll hear from people, well, hey, I'm getting closer to getting to the nursing home. I can't make gifts anymore. Well, it's true as it relates to gifts to third parties, meaning anyone that's not your spouse. There are no gifts between spouses. But as it relates to making gifts to children or paying their expenses, those can be penalized by Medicaid. So what are some examples we commonly see? Paid their credit card bill, paid their wedding, paid their tuition, paid anything to them that's not otherwise my expense. Those are deemed gifts. So how does that work? Let's say an individual applies for Medicaid July 1st of 2023. In the prior 5 years, they had given away $100,000 in assets through paying for the wedding, the education, everything we just talked about. There's going to be a penalty that's associated with that. That penalty is going to be implemented by the Department of Social Services. The way you determine a penalty, in Erie County, the most that a Medicaid patient is paid for to the facility is $12,130 per month. So to determine the penalty on $100,000 worth of gifts, you divide $12,130 into 100, and what you come out with is about 8-point-something months. Ultimately, what that means is the applicant has to private pay the nursing home bill for 8 months before Medicaid picks up in month 9. So that's why the gifting becomes very difficult, because the money's gone now. You've already paid out what you're going to pay, but now you have to pay the nursing home for 8 months. How do you do that, and where does the money come from? Well, that's where the elder law attorney comes in to try and figure out how we're going to create enough resources or enough income stream to try and pay that nursing home bill. That's also the business model you should understand from the nursing home's perspective. If you are ever going to a nursing home, the nursing home is going to tell you, we'll do the Medicaid application for you. Bad move most of the time. The nursing home is a business. The difference between a Medicaid patient and an applicant who's the difference between a Medicaid patient receiving Medicaid and someone who's private paying. I'm not going to say the name of the facility, but there are facilities out there charging $20,000 a month for skilled nursing. The only difference between the private pay patient and the patient on Medicaid is a private room. That's it. Somebody who's privately paying is in a private room, whereas the individual who is on Medicaid is in a shared room. They cannot provide you any differential in care, but the difference is for that facility charging 20 grand a month versus the person on Medicaid, they're getting 20 grand from the private pay patient, they're getting $12,130 from the Medicaid patient. So it's almost $8,000 a month per patient. That's why the facility oftentimes will tell you, you have to spend down until you get to these eligibility limits, because it's to their financial gain for you to be paying them 20 grand a month as opposed to getting on Medicaid. Our jobs as elder law attorneys is to accelerate getting you onto Medicaid through a crisis plan, which will be the last thing we're going to talk about here in a minute after the irrevocable trusts. So kind of the takeaway is, if a family member needs skilled nursing care or it's going to an assisted living facility, you should be contacting an elder law attorney. You should not be going through the nursing home to do your Medicaid application unless you clearly qualify. If you only have $30,000, $40,000 worth of assets, that's a different story. But if there are assets that are over and above these eligibility limits, you need to be contacting an elder law attorney immediately to assist you through this process, because there are more likely than not monies that can be saved as opposed to being paid to the nursing home. The next few slides, I'm not going to go through these, but what I did is I put in here, we always get asked about the burial plans. What can I include in a burial plan to qualify for Medicaid? The burial plan has to be irrevocable, meaning once it's paid for, the money is tied up in a trust account and it's only available upon death to pay for the expenses. Conceptually, the idea is you go into a funeral parlor, whichever one you'd like, and you go through an itemization with them of the things you want, and they tell you how much it's going to cost, and you pay them. And the money goes into a trust account, and upon death, the assets are then used to pay for your funeral expenses. So if you have more money than you're allowed to have, the elder law attorney more likely than not is going to say, hey, your burial plan should be paid for, your spouse's burial plan should be paid for, we can pay for your kids' burial plans, we can pay for the spouses of kids, etc. So it's just a way to keep money in the family and for, expenses that will be forthcoming in lieu of putting it into the nursing home. So these next several pages, again, you're going to get a copy of this slideshow or this PowerPoint, but all these next pages, I'm not going to go through these. These are just specific items that you're allowed and not allowed to keep in your funeral plan. The big one is you can't prepay the breakfast. They don't allow you to do that. But almost anything else that would come naturally with cremation or a burial plan, you can prepay that and include it. They are transferable between funeral homes. We get that question all the time. I want to start with this funeral home and now I want to go to a different one. Yes, they are transferable. But again, this is all just a very detailed list of right out of the statute what you are and are not allowed to include in your prepaid burial plans. So finally, irrevocable trusts, otherwise known as an asset protection trust. Irrevocable means what you think it means. It means that I am setting up a trust. I'm designating a trustee who cannot be me, and it can't be my spouse. And I'm putting money, I'm transferring assets or money from myself to my trust. The assets that are transferred to the trust are now off the table to me. Meaning, if I put 100 grand in a bank account that's now owned by the Dan Schuller Irrevocable Trust, I can't tell my trustee, you got to give me the money back. That violates the terms of the trust. It would not be an asset protection trust. The assets would not be protected if you needed long-term care. So when you are thinking about setting up one of these trusts, you really need to have a thoughtful, in-depth discussion with your elder law attorney about not only your budget, but what your life expectations are. Common question that an elder law attorney is going to ask you is the first big asset, the easy one that most times people will move out of their name, is their house. Question that I always ask, and I'm assuming other elder law attorneys ask it as well, is what's your plan with the house? Now that you're retired, you have a better idea of what your plan is moving forward. If the answer is, well, we need to sell the house and live off the money, then you shouldn't be transferring it. Because by transferring it, you're reducing the money you would receive if it's sold. But if the plan is, well, we're going to live in it for 5 or 10 years and then maybe we'll downsize down the road, or we want to live out our days in this house, then you should be talking to your elder law attorney about getting it out of your name. How do you do that? It's a deed transfer. The attorney prepares a deed that transfers it from husband and wife to husband and wife's trust. The date that deed is signed, you start a 5-year look back. So if you or your spouse apply for the nursing home in 5 years and a month or any date after 5 years, Medicaid can't come after this asset. It's now off the table. The same idea applies to any other asset you put into the trust, whether that be an investment account. I have a savings account. I've accumulated a couple $100 grand in a savings account. I never touch it. I don't need it. I live off my income. I have minimal expenses, whatever. Well, you should probably be looking at getting that savings account out of your name to avoid having to pay it to the nursing home. How do you do that? You open a bank account that's owned by the trust and you transfer the money in, and now you've started your 5-year look back. So the elder law attorney generally will have you fill out a questionnaire in advance of the meeting that details all your income and all your assets and all your liabilities. And at that meeting, they should be talking to you about prospective plans. What do your expenses look like? How much are you dipping into your savings to cover your monthly costs? Because if the answer is a lot, you shouldn't be moving the savings account out of your name, because once you move it into the trust, you lose the direct access to it. So it should be a thought-provoked or invoked conversation about what makes sense to move out of your name and what doesn't. We, as elder law attorneys, will almost never transfer ownership of your retirement account for the reasons we already talked about. If you need Medicaid, you don't have to spend down the principal balance of the retirement account. They only take the required minimum distribution, the income that's being paid out. So, again, it works very similar to a living trust in that when you pass away, whatever is in the trust passes pursuant to its terms. Upon my death, all to my 3 kids, or to my grandkids, or to charities, whatever you want it to say. The assets that are owned by this trust upon death don't go through probate, same as the living trust. They are also paid out in a timely fashion. The difference between the living trust, though, and this trust is the asset protection. So the assets that are owned by this trust for 5 years or more are off the table from the perspective of the nursing home. Whereas the living trust, the assets that are owned by the living trust, remain available to you and therefore are accessible by Medicaid. So why is the house the automatic, for the most part, what we see, people moving the trust or the house into the trust? 3 primary reasons. 1, these are called grantor trusts, and that's just a tax terminology. What that means is that if I transfer my house into my trust that I set up, I still have the right to live there. I still maintain my property tax exemptions. I pay all the expenses associated with the property. I effectively have life use. If 5 years passes, again, the asset is off the table for Medicaid. And then when I pass away, it can either be sold or given to whomever almost instantaneously. No need to go through court. The second reason why people proactively put the house in is, well, if you're that 5 to 10 year plan person who's thinking, I'm 70, I'm going to live in the house for 5 or 10 years, and then maybe I'll downsize to a condo or I'll go to, some other type of living arrangement. If you get to year 5 or year 10 and you decide you want to sell the house, you can do that. The trustee will sell it for you. So you don't sell it, your trustee sells it. The trustee can then take the money received from the sale of that property and invest it into a new property for you to live in. That doesn't reset the 5-year look back because the transaction occurred entirely through the trust. It did not occur through you as an individual. The trustee did it as the owner or operator of the trust. They sold it, and now the trustee owns the next property. So there are ways to sell and reinvest. What happens to the excess proceeds, if there are any? Just goes into a bank account owned by the trust. So the money remains protected, and we now have you a new place to live. And you still remain obligated to pay all the expenses, etc. So there's no expense to your trustee as far as maintaining the house during the lifetime of you. The third reason is liability protection. So there is another tool to get the property out of your name. It's called a life estate deed. And a life estate deed is effectively a deed that transfers ownership of your property to your children or whomever, and you take back life use. It's a more cost-effective mechanism, but there are some more risks to doing it. If 5 years passes, the property's protected. Same way it would be if you transfer the ownership to the trust. But there's a couple major differences. Difference 1 is if your kids get sued, or your remainder owner gets sued, or they have to file bankruptcy, or they get a judgment against them, that can impact title to the house and result in a lien on the property because the kids have a remainder ownership now. The second is if you want to sell during your lifetime, unlike the trust where the money goes back into the trust, your kids will get a check instead of you getting or having available all of the proceeds. So life use has a value. So if you're 80 years old, your house is in your kid's name and you decide to sell it, there's an actuary table which determines what percentage of the proceeds you would get for your life use. But the rest of the proceeds go to your kids. It's not up to them to give the money back to you. If they don't, well, how are you going to reinvest in the new property if that's where you're going? You're trying to buy a condo. There's no requirement they give the money back to you. Contrary to a trust. If the plan is, hey, we need to sell and we need to buy a new place using the money from the sale. The 2 things that the creator of this irrevocable trust always retains, even though they cannot be the trustee and they can't access the funds for themselves that are in there, they always maintain control over who will be the trustee and how the beneficiary structure is set up. So if you get to that point where you want to sell and child 1 says, I'm not selling it, well, we replace them. We just put the next trustee on whom we know will sell it for us. and then that trustee will sell it and they'll cooperate and the money will be available. So there's a little bit more security and protection, creditor protection with the trust. A trust will cost more than the life estate deed will, and because it's University Express, we're not allowed to talk about fees, but I can just tell you generally that working in the field that a life estate deed, it's a cheaper option and it accomplishes the 5-year look back, but it lacks several of the protections that a trust does, which oftentimes leads to more of a cost. The other thing is the irrevocable trust can be a depository for multiple assets. So if you, again, have that savings account you want to put into the trust, you can do that. If you don't do a trust, your only option is to retitle that account to your child's name. The problem with that is, let's say you do retitle it. You put it in child A's name. They spend the money. It's only been 3 years and now you need to apply for long-term care. If you remember that penalty example we talked about, that's what you're going to be dealing with here because the money's gone. It's seen as a gift. You didn't make it 5 years. If the money's in the trust, again, you are appointing a trusted trustee to manage the money. Presumably the money would still be there. If we don't get to 5 years, we can undo the trust. It then becomes available and we can do a crisis plan, which is the last thing that we're going to talk about after we get through this slide. Other thing to note about this type of irrevocable trust, any income that the trust generates is paid to the creator of the trust. So you can get savvy with these. You can bring in your financial advisor and say, okay, here's what I want to do. I want to transfer 100 grand into the trust. I don't want to just put it in a bank account though. I want it to be an investment vehicle. The financial advisor says, okay, what's the motive? What's the goal here? Well, I'd like it to pay off some income. Well, we sit with the financial advisor and the trust now becomes the owner of some type of investment account that has an income stream. So while you're starting the protection of the 5 years, any of the income that asset is generating pays back to you as the creator and is then taxed at your tax rate instead of a trust tax rate. So there are other ways to use this trust for your benefit other than just storing assets to get by a 5-year look back. As we talked about, the trust avoids probate, just like a living trust, so any of the assets that are in the trust will pass immediately or in a timely fashion, pursuant to the terms of the trust at a much more cost and time-effective manner. Last thing, I keep talking about this crisis plan. What do we do if you don't have 5 years? There's a planning technique out there, and I don't want to get too into the weeds on how it actually works, but conceptually, I just want you to remember that this exists, and the person telling you it's too late is oftentimes wrong. It's called the use of a promissory note and a gift. And in its simplest terms, it's called crisis planning. It means you have too much money, either you and your spouse have too much money, or you individually have too much money to qualify for Medicaid when it becomes time to go to the nursing home. Your family should immediately be calling an elder law attorney. If you have that power of attorney that we talked about at the beginning of the proceeding, or at the beginning of the presentation, we can use that power of attorney to save about 50%, sometimes a little more, sometimes a little less, about 50% though, of whatever your excess resources are in lieu of paying it all to the nursing home. So let me just give you a quick example. Single individual comes in, they have $230,000 in cash in their name. They're allowed to keep 30, which means they have $200,000 more than they're allowed to have. In the week or so leading up to this individual applying for the nursing home, we make two transfers out to child A. $100,000 goes into one bank account in child A's name, $100,000 goes into the other bank account in child A's name. As I told you before, you can't make gifts, right? The nursing home is going to penalize you for doing that. That's okay. I've already pre-calculated, or the elder law attorney has already pre-calculated what the penalty is. So under this example, as we talked about earlier, if you give away $100,000, the penalty is going to be about 8 months. You're probably thinking, well, how am I going to pay? I only have 30 grand left. I'm on Social Security. Maybe I have a small pension. How am I going to pay $15,000 to the nursing home every month? The gift that we gave to child A, the 100 grand gift, sits over in its own bank account. The other transfer to child A, the other 100 grand, is what's called a promissory note or a loan. Medicaid does not care if you make loans because loans are repaid. They only care about gifts because gifts aren't paid. So forget about the gift. 100,000 in bank account B, we'll call it. Forget about that. It's over in its own world. We're only going to be focused on bank account A now, which is a $100,000 loan to child A. I told you there's going to be an 8-month penalty period that we need to repay the nursing home, or we need to pay the nursing home bill for 8 months before Medicaid pays in month 9. So how do we create enough income so that the Social Security plus the pension plus whatever else are enough to pay the nursing home? What we do is that $100,000 loan that we gave to child A, we restructure the payments over 8 months. So now what happens is once a month for 8 successive months, child A cuts a 1/8 check from the $100,000 account back to mom or dad. That plus the income is enough to pay the nursing home every month. We would have, the elder law attorney pre-calculates to make sure that the income, that the loan produces a sufficient loan payment back every month to make sure there's enough income between the loan payment, the Social Security, and the pension to pay that $15,000 a month bill. What happens in month 9? Starting in month 9, the promissory, the note, the loan will have been repaid because we paid it back over 8 months. And just to be clear, the child is not using their own money. They're using the $100,000 mom or dad gave them, and they're just repaying it back to them over 8 months. So at the end of 8 months, the loan has been repaid. The penalty period has been repaid. So now Medicaid is paying, except for whatever the patient's income contribution is. And again, that's everything but $50 a month. But the third and most important thing is that other $100,000 gift that I told you to forget about over in bank account B, that's protected from the nursing home. They can't touch it now. It's now free and clear to child, grandchild, whomever your beneficiary was, anyone but your spouse, effectively. So the idea is, it is never too late. If you think someone is going to a nursing home, or they're going through hospitalization, they're starting the rehab process and it looks like they're not coming home, or even if they just got admitted, it is not too late. You should be calling an elder law attorney. The worst the elder law attorney is going to tell you is, hey, under your circumstance, the finances don't make sense to do the gift and note. There's just not enough money to do it. Most of the time, though, there's a savings to be had for the family, short of just paying it all to the nursing home. So again, as elder law attorneys, when it comes to Medicaid, we always say our job is to accelerate you getting on Medicaid and making you look poor when in reality you're not poor. So that's really the biggest takeaway when it comes to, if I don't have 5 years, but I need Medicaid, or if I just have too much money and I need Medicaid, it's not too late. You need to be calling an elder law attorney, not a general practitioner. Only elder law attorneys really do this stuff. It's too complicated. The techniques that are implemented are very specific, and there's large consequences if it's not done correctly. So that's really the big takeaway here is start your planning. Usually 65 to 70 is the ripe age. You're retiring. That's the ripe age to start talking about the 5 years. Doesn't mean if you're 75 or 80, you shouldn't be addressing those. That's still within the time frame. It's just kind of the ripe age is, I'd say 65 to 70, 65 to 75 is when you want to start really looking at getting assets out of your name, because now you've more than likely retired and you have a better idea prospectively about what your life plans are. But even if you don't have the 5 years, it's not too late. You should be calling an elder law attorney. The nursing home should not be doing your Medicaid application unless you clearly are eligible, meaning you have minimal assets. Otherwise, you should be talking to an attorney about this stuff. Let me just end this. Elisa, do you know how I can see the chat now? I saw a couple things popping up, but I don't know how to access the chat.
Yeah, okay. So I think I can, oh, I can't. You know what, on the bottom of your screen, Dan, where share is, I think you can X out of your presentation. But, and everyone, thank you so much. That was such a fantastic class. Oh, there you go. I feel like I learned so much as well. I hope you all did too. Like Dan said, we'll be sharing this PowerPoint in the next day or so with everyone via your email that you registered for the class with. So we're getting some thank yous. Dan, your information, as I recall, was on the front page of your PowerPoint, correct?
Okay, yeah, it's on page 1 of the PowerPoint, so I will send it out and everyone will have access to that. I see there was a chat here, or there was a question from Somebody asking, it's a private question, so I won't say who it was, but
Yeah.
the question just generally was, when you say income from the IRA, do you mean the RMD or actual income, the interest? It's the RMD. So even if you're not at 70, I think the new age is 73 for this year. Even if you're not receiving your RMD and you need the nursing home will require that we calculate what the RMD will be, and then they divide the RMD by 12. So if you get 12,000 a year from your IRA, they divide that in 12, so that every month it's $1,000 contribution to the nursing home. I think that was the only question I see. Did you see any else, Elisa?
Yeah, no, that just came to you, so I'm glad you opened it up. I'm gonna just stop